Hello friends, welcome to Juris Lens. In this video, I will be covering various schools of jurisprudence. Before jumping directly into the school, we must understand why there are various schools of jurisprudence, what they teach us, and the significance of those schools. Various schools of jurisprudence serve to provide unique theoretical perspectives on the nature, purpose, and function of law. Learning these schools is useful for law students and legal practitioners because it helps them to critically analyze and understand existing laws. By studying different theories, one can better analyze how laws are created, interpreted, and applied within a given legal system and how it has evolved over a period of time. Now, let us go through what is analytical school. John Austin is considered as the father of the analytical school. According to him, law is a command of the sovereign backed by sanctions. So the sovereign is politically superior people and the command given to politically inferior people. This means law is an order given by a political superior, that is sovereign, to a political inferior, that is people, and its violation results in punishment. According to Austin, while making laws, morality is irrelevant. What matters is that the rule comes from the sovereign authority. Now let us go through some of the examples of law as a command of sovereign. In traffic laws, stop at a red signal. This is a command by the state. If disobeyed, a penalty or sanction follows. In criminal laws, theft, murder or assault are punishable because the sovereign prohibits them. Even if society disagrees, the rule remains as long as the sovereign enforces it. Similarly, in taxation laws, citizens must pay taxes. This is not about morality but obedience to sovereign command. Non-compliance from paying taxes leads to sanctions or penalties. Quarantine rules during pandemic. Wear a mask or stay home during lockdown were sovereign commands, violation of which attracted penalties. Now let us go through the characteristics of analytical school. There are 4 characteristics which are central to the Austin school. Number 1, sovereign. The sovereign is the supreme authority or the ultimate source of law in a given legal system. Here, the sovereign doesn't answer to any higher authority and their commands are seen as the foundation of law. For example, in a country, the government which is elected through democratic means is considered as the sovereign authority. For instance, the Indian Parliament is the sovereign law-making body in India with the ability to create laws for the nation. Number 2, command. Commands are not a request or directive by the sovereign. It is a command that the law must be followed by the people. For example, a traffic law that says no one shall drive above 60 km per hour in a city area is a command from the sovereign issued to the people to ensure public safety and order. Number 3, duty. When a command given by the sovereign, it is the duty of the people to follow it. Failure to fulfill a duty results in sanctions. For example, if a citizen is required by law to pay taxes, this becomes their legal duty. Not paying taxes is a breach of that duty and the sovereign through the government can impose sanctions. Number 4, sanctions. Sanctions are the penalties or consequences that individuals face if they fail to comply with the commands of the sovereign. These sanctions are essential to ensuring the enforcement of the law. For example, if someone violates the traffic law by speed, they may be fined or face imprisonment as a sanction. These penalties are the consequence of not adhering to the law and they encourage compliance. Here, Austin divides law into 2 categories. Number 1, law properly so-called, and number 2, law improperly so-called. Law properly so-called laws are positive laws. Positive means law as it is. So according to Austin, positive laws are perfect laws that the law must be studied as it is rather than as it would be. Law has nothing to do with the past and future consequences. For example, in some countries, capital punishment is still legally practiced despite global debates about its morality. Under legal positivism, these laws are valid because they are enacted by the sovereign authority, even though they might be subject to change based on future ethical perspectives. The law is valid as long as it is enacted and enforced by the current sovereign authority, regardless of moral debates about its ethical implications. So these examples illustrate the essence of legal positivism, focusing on the law as it exists now, regardless of its history or its future evolution. So the emphasis is on the present authority of the state and its power to create valid laws. Jeremy Bentham is the guru of John Austin, further contributes to the Austin school of thought. According to him, the ultimate end of the law is the greatest happiness of greatest number, which means that every law must create happiness and avoid pain. Law should be judged on 2 points, that is pleasure and pain. The ultimate purpose of the law is to bring pleasure and avoid pain. Bentham pleaded for codification of law. He was not the supporter of the judge-made law and he rejected the natural law as well. Now let us go through the criticisms of Austin command theory. Number 1, ignores morality. Sometimes law may be unjust but still valid. Critics argue that morality cannot be fully separated from law. Law and morality both must go hand in hand according to the critics. Behind a right to equality, there is a morality. Behind every fundamental duty, there is a morality. Number 2, absolute sovereignty unrealistic. In modern democracies, power is divided among executive, legislature and judiciary. No single sovereign exists there. Based on this, Austin theory were criticized. Number 3, customary laws. Many legal systems recognize customs as binding, but Austin ignores them since they do not originate from a sovereign. Custom is the important source of law in which Austin ignores it completely. Number 4, international law. International law is widely accepted and enforced, yet Austin considered it law improperly so-called since no sovereign enforces it. Today, treaties and conventions are legally binding between the nations. For example, International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights 1966. Number 5, static approach. Law is seen only as commands here, not as a dynamic system evolving with society. Law has to be changed according to the needs of the society, but in some branches of laws, commands are irrelevant. Countries like India, sovereignty rests in the people and is limited by the constitution, not absolute as Austin imagined.